is the fact that customary use is public use of private property. That's why we're going to start by talking about what is public property, what is private property, and try to delineate that in Walton County. Okay. How many miles of beach do we have in Walton County? 26 miles of sugar sand beach, of the beaches of Walton County. How many of those 26 miles are public? Somebody's already calling. I heard over half. Anybody else want to say how much of the beaches?
Less than 5.
Yeah. Less than 5 miles?
Yeah.
Okay. Other ideas? All right. 13 miles, approximately. Yeah. Approximately. I actually, did these measurements, but you will go and verify. Let's go through them together and let's look. This is from the Walton County's GIS mapping service. If you are a realtor and you don't routinely go to Walton County's GIS mapping service, shame on you. You really should put that as a good piece of gear. So each of these minutes of longitude are 1 mile. So from the Okaloosa-Walton County line all the way to Topsail is the area in which there is an erosion control line. We're going to talk about that in a bit, but take it as a fact right now that means that there is beach that is there that is owned by the public. And I'm going to show you where it is and why it's there. 5 miles of beach has an erosion control line on it. That erosion control line has been there since the mid-2000s. It predates this litigation. There was nothing about this litigation that impacted that erosion control line. Didn't change it, didn't move it, didn't establish it, didn't eliminate it. It's always been there. And, it hadn't always been there. It was been there when they put it in, and you put it in when they did the beach nourishment. So that's what we're going to talk about, and that's how it comes. So then you go to Topsail State Park, 3.2 miles of beach. Did you know that that was the largest eminent domain case in the state of Florida? The Topsail State Park was an eminent domain case with St. Joe. Judge Remington, one of our partners' dad in Okaloosa County, when he was in Walton County, handled that. The largest eminent domain settlement that resulted in the establishment of Topsail. 3.2 miles of public beach. Then you go from here, you go to the Dune Allen area, and there are 2 different ones there that are combined in that area. That is the new beach access that the county bought in front of Stinky's, the 2 lots that they turned into a parking lot, and then the Dune Allen right next to the entrance to Fort Panic, that area. So that's about 0.3. And then you have the Edwalene and the Spooky Lane area is about 0.2 here. And that's public. And then you get down to Grayton Beach. And at Grayton Beach, you have about 2.5 miles with the exception of that little red area, which is Gulf Trace. And I'll show you that on the maps. And 3 lots in Grayton proper, that tiny little red there, and I'll show you that. There were 3 lots that held out. So 2.5 miles there, and then you get to the great Seagrove, Mr. McGee. We'll talk about why is this public and a lot of others are not, but that's the Seagrove Beach area. And then you have Deer Lake State Park, about a half mile, and the area there, publicly accessible. And then you have the Inlet Beach, Regional Beach that is there. And I did not include Camp Helen. That would add another 0.5, but of course, as you know, that's in Bay County, even though it's mostly accessible. I mean, it's obviously more easily accessible.
You didn't mention Seagrove and inlet size.
Oh, yeah, so inlets is about a half mile, and what was the other?
Seagrove?
Yeah, 0.8. So about 0.8. These are about. That's what the little squiggly is, about.
Read the red text. So did you say of the 26 miles of beach?
13 miles of beachfront in Walton County is publicly owned, controlled property.
13 of the
13 of the 26. And that was, if we added 5, 3.2, 0.3, 0.2, 2.5, 0.8, 0.5, and 0.5, we should be at 13. Correct me if I'm wrong. Yes,
So
ma'am.
I'm doing Allen, the county just purchased 2 properties, we should add another mile.
Thank you. And that, I want to be clear, this does not, and that's why I think the gentleman over here who said over half wins the prize. Because if you add up all the beach accesses that the county controls, I included, because I included the Ed Walleen and Spooky here as a 0.2 because it was enough to make, otherwise they're like 0.00, you know, some of them are only 33 feet, some of them are 66, some of them are larger. If you add all those up, you get more. So the point, I think the accurate answer is over half of the beaches in Walton County are public. Now, if they're publicly owned or controlled property, okay, ownership is, we're going to talk about over here, the difference between ownership and then control. And we certainly are going to talk about that when you talk about the Seagrove area. Ownership and control is a little bit, we won't get into too deep. Yes, ma'am.
Can you go back to the Okaloosa line part,
Yes,
the Topsail, where is that?
So
Sandusky Resort?
So this is the Okaloosa line,
Right.
we know that, right?
I do,
And so this goes to Topsail, where Topsail starts.
right?
So that is about 5 miles. That is where the erosion control line
Along
is.
Old 98, or where
Correct.
is that?
Yeah, so that's what we call Miramar Beach.
Okay.
Essentially, 30A is coming down, essentially everywhere except, 30A. It's either public. So essentially, 30A is coming down here, right? This is Beach Highlands, Stalwart Lake here. And so Topsail starts here. So essentially from here back, there are some exceptions. There are some exceptions. The beach, I'll show you on the maps. There, 4 Mile Village is an example.
So there's no ECL in Topsail because it's a state?
Thank you.
But it did receive beach renourishment.
Thank you. There's no erosion control line in Topsail because the public already owns it. The erosion control line is established when beach nourishment is used and public monies pay for sand on private property. And we're going to talk about that.
But it did receive it.
I don't know the answer. But, and I have somebody who is writing down questions, and Cecily, I forgot to introduce Cecily. Cecily, please. Cecily is our marketing director, and she is the logistics and coordinating. And I sent an email to Cecily. I said, they're going to ask me questions I'm not going to be able to answer, and I want you to write them down so we can then post them. I don't know the answer, but we'll try to find out.
Yeah.
Oh, Mr. Davis, I knew he was in the back for a reason. The answer is yes. That they did put sand nourishment on the Topsail. Okay, other questions about this? This is important, okay? So, did the judges, all of the litigation, all of the effort, is there customary use established on any of the areas that I'm showing in red of the public property?
No, it's public.
No, it's public. You can't have customary use against the sovereign. You don't need to because the public already owns it. The public can use this. Now, again, I think one of the throughout the afternoon, I'm at the pause and make sure that I'm checking myself. It has been my personal observation that if you want to go to an area that is that there are not a lot of people, then you should go to a public state park. Because for whatever reason, people don't want to pay $5 to enter the park and have a park and, parking area and a bathroom and this, that, and the other. So there are restrictions on the use of public property, but those restrictions are that's a governmental issue. It's not a private public property issue. And I think you could probably argue and you say, well, I mean, seriously, nobody can get here, right? I mean, that is a long haul. There's a access here, and that's a long. I understand that. I mean, this is not about access, but I'm just saying these are public beaches. The public owns them. The state controls them, or the county controls, and they have ordinances and rules. And so that's why you can use Edwalline Park at certain times, and certain times, they lock the bathrooms for cleaning. And then the state park, Drayton Beach, can charge a fee to come in and use it, and they do, and they have rules and this, that, and the other. So I mean, there are rules, I get that, but there are not. It is public. Okay, so now we have established that over half of the 26 miles of sand beaches are public, so why are the others? Why isn't the other part of the beach public? I mean, it's the beach. Why isn't it?
Property lines extend to the main high water line.
Because in Pensacola Beach, it's all public. I go to the beach in Pensacola Beach, I go anywhere I want. It's all public. The beaches are all public.
The sovereign lands.
If you are the listing agent, who's ever sold a house in Pensacola Beach? Did you sell one of these Gulf fronting ones? The southern boundary of any of these is the landward toe of the dunes. There is no ownership of the beach. The beach is public.
That's the same in Bay County?
Not the same in Bay County, not the same in Perdido, also Escambia County, Florida. So, but this is an example of why this is not a uniform situation throughout Florida. This idea of beaches are, because in Pensacola Beach, the sovereign retained ownership of the beach. Why didn't it happen? What happened over here? You sold it. You're selling it. You sold the beach, and we're going to see how. You're selling the beach. It's generating a whole bunch of money. I mean, these are some tremendously profitable areas. It's selling property, off the beach, and you're selling property on the beach, and it's being sold because the sovereign, remember, just a brief history lesson, and I understand we won't go into religion, but the history of the conquest of the United States is a history of conquest. It's a theory, land of theory. If you capture it, then you own it, even though there were people who were living here. I'm not making a judgment call on that. I'm just saying that through a series of events, trust me, the United States is the one who ended up with all of the land, right? Andrew Jackson, you know that? Andrew Jackson and all that. And then when there was a state, the state of Florida was admitted into the Union only if, and specifically because, it recognized the sovereign, the federal government, United States government, right to the ownership of the land. So when Florida became a state, that did not make the land that the United States owned Florida land. It still was retained by the federal government. Why is Eglin Air Force Base the largest domestic Air Force base, military base in the world? Because the government owned it all. He owned these 3 counties. It owned all this land. It didn't have to go acquire it and buy it and whatever. It owned it. Well, when did it sell it? And you'd think, well, gosh, I guess, 3 years after Andrew Jackson left. But he didn't in Walton County. He didn't sell this area until 1949. I mean, my mother was 9 years old, right? That wasn't, it was 1949. And this area is Dunaway. This is Stalwart Lake. This is the Beach Highlands. This is the outfall of Orchard Lake. This is the survey, government land patent, 1949. This is publicly available, accessible information. If you have Mary Grace who can find it for you.
One point of clarification, that is the land patent from 1949. However, the Dunaway area of lake was sold by the President of the United States in 1912 and then recorded January 8th of 1913.
Thank you for that clarification, because this area, even though it's showing the outfall, is not part of this. This is the survey, and I'm going to show you, well, let's just show you now. So you'll see this is the Dunaway that you're referring to. This is block 37, this is 38, and block 38, I can tell you, and if you look at a property appraiser listing of that triangle right there, you will recognize it as right here is Fort Panic, and Fort Panic runs to about right here. And that is the 1.36 acres of Fort Panic. Let me see if I have that. Okay, so, and you see that's that pond north of, Stinky's, like right here, Allen, right? And then see the outfall. So it's not talking about this. And this survey in 1949 was not the land patent. Okay, the survey is when they did the survey of it. The land patent is here, 1954. Okay, so the United States of America, the sovereign, owned this property in 1954. Okay, not that long ago, actually, in times. My neighbor Diane, thank you for coming. And you wore your yellow. Thank you. And so in 1954, that's when this land patent deeded lot 38. Remember, that's lot 38, that 1.36. Okay? All right, so please allow me a personal privilege to go back to this slide so that I can repeat what I said while Diane's here. What did I say to everyone? Who owns this property? The public has always owned this property. Pensacola Beach is publicly owned. It is not privately owned. That is different from this area over here. Diane and her band of Yellow Save the Beach folks have been passionate and I think very successful in maintaining that. So, thank you, Diane. I'd hate to.
You're most welcome. I appreciate that.
So Diane and I were neighbors, and she helped me out so often with my little girl. Emily would get off the special needs bus and wander often, and I would get a call. Will, I've got Emily. So thank you, Diane. All right, we're back to 38, block 38, the government land patent. This is the deed, and they're called land patents, right? When you buy it from the government. It's a land patent. It went to Mr. Fisher. They sold him the whole lot. Now, 1954, Federal government, when you sell property, you can restrict that property, right? And in fact, all land patents in Walton County share at least one reservation. And that's this reservation here, and I'll read it if you can. This patent is subject to a right-of-way not exceeding how many feet? I know you know this because they're so important. Not exceeding the 33 feet in width for roadway and public utilities located along the north and east boundaries of said land. These are the 33 feet government land patent easements that I know you've talked about because you've got places right now that you're selling that's the only way you can access them. And some of them you have to make the road down through the forest. So what does that mean? Each of these lots, this is lot 38, right? Lot 38 goes here, and this is 37, and then it comes down, right? Most of the lots, you know this because there are many of these that still exist, these 2.5 acre lots, 2.52 acre. These lots are here. The northern 33 feet and the eastern 33 feet. And as you can see here, the reasoning for that is because it creates an access grid. Access all the way across here, access all the way up and down here. So, and each of these, if you knew the math, of 330 feet. That means that the way the government land patents, there should be, and these all run to the Gulf of Mexico. That's a crude mean high water, but it runs all the way through. That's where the majority of the beach accesses come from. Because each of these land patents reserved a 33-foot access for right-of-way going up and down. So theoretically, unless the government did something, there should be an access every 330 feet, right? So that's what that is. Now, life and change and development and this, that, and the other, we're going to talk about how that happened, but that's what the government land patent deeds did. That's what that deed did. And but for, this is a Will Dunaway, I'm just going to put it out there, but for just a few words at the end of this and every one of them, we could have solved all of this. Forgive me, property owners. But if they had said, and reserving unto the public the beach from the toe of the dune to the mean high water line for public use, we'd all been done. It'd all been over. It would have been a deed. It would have been a deed restriction. It would have all been over. Now, that's not there, and that is why you can sell some of these properties, and this certainly would be the case. The properties at Fort Fanny, for instance, they go to the mean high water, private property. So you could sell them. Now, what does it mean if you have and are selling private property? What are you actually selling? And what rights come with that? The deed tells you, and well, Florida law tells us too. Chapter 70 tells us what are the rights. This is referred to as the bundle of sticks. Each property has a bundle of sticks. The fee gives you all of the bundles until there's something taken away. If you owned a property in one of the land patent, one of the sticks that you don't have is that 33-foot right-of-way because somebody else has that ability to come across. And mostly those are developed and they're built. It's where most of your roads are. But that's part of it. You may get a piece of property that's subject to a utility easement or a drainage easement or a insert whatever type of property rights can go in there. That's there. But otherwise, if you own private property, you have the right to possess, acquire, and protect it. The right to use and enjoyment, the right to exclude others from it, The right to dispose of it, the right of due process, the right of just compensation if it's taken by the government. That's a Fifth Amendment, U.S. Constitution, and part of the Florida Constitution. And in Florida, the right to relief of payment and compensation if there's a new law that changes and inordinately burdens it for the protection of the public. Because the idea is that if it's good enough for the public, then the public ought to bear the cost of it. And so that's called the Burt-Harris Act. Those are the rights that you get when you get private property. And you should know that because you're selling it, right? I mean, so you should be able to let folks know, and then you have to let them know what they don't get. That's why you get title insurance, right? I mean, that's why you get all those exceptions and the survey exceptions and all those kinds of things. That's the difference in public and private property.